Got some breaking news. The Manhattan District Attorney, right on time, has told Judge Merchan not to vacate or throw out the criminal conviction of Donald Trump just because he happened to win the presidency, and maybe even sentence him before the inauguration, if that's possible. And they've made some reference to maybe using a doctrine that applies to dead people in order to do it. I can't think of anybody better to kick it around with than my colleague, friend, and confidant, Karen Friedman Agnifilo, formerly of that very office. And we're here on this duet to break it all down for you. The last filing, I believe, before Judge Merchan makes a ruling about whether a former president, soon to be president again, is going to jail or not. Karen, how you doing?
Yeah, I'm okay. I'm recovering from a little procedure I had on my knee, which is, been a little unpleasant, but other than that, I'm great.
We're gonna have our midweek edition of Legal AF tomorrow. Nothing stops us. Not surgery, not convalescence, nothing. And you're here now. I was like, wow, she's back already? That's crazy.
Well.
Okay. So I'll frame it, then I'll turn it over to you for the filing, because we talked about this on Legal AF, and this is sort of a good catch up here for updated reporting. The Judge Merchan, has been sitting on a couple of things. He's been, because the parties asked him to. He was about to rule on the 12th of November on whether Donald Trump had immunity or not, based on the Supreme Court decision in July for his criminal convictions for things that happened before he was president the first time, let alone after. And so he was about to rule, and I believe that he was going to rule against Donald Trump on that. But the other side said, oh, we're going to file another motion. A motion in the interest of justice under a certain provision of criminal law and procedure in New York, and knowing that they needed a complete record, and your old office said, all right, we'll agree, set a briefing schedule. The Judge Merchan said, okay, if that's what you want, I'll set a briefing schedule that the Manhattan DA's office is asking for, which is a short one. And the judge said, I'm going to issue my immunity order eventually, and I want to be briefed on whether, in the interest of justice, if anything has changed, if the world has changed in the world of the criminal conviction or sentencing, because Donald Trump got elected again. And so he said, I want two briefs. And the first brief came in about a week ago, and we reported on it. And you can talk about what the old warmed over leftovers that were in the refrigerator of arguments that Donald Trump's lawyers raised over again. Judge Merchan has a daughter. Oh, here we go again. She works for a living. Oh, okay. There's a bias here. Michael Cohen, MeidasTouch, Michael Popok, all sorts of things, crazy things having no bearing on whether there's any immunity or supremacy clause immunity or anything else that would throw out a conviction by 12 not that angry people in jurors of New York against Donald Trump in 34 felony counts. And then it was time for your old office a week later to file their paper. That's the only two papers that the judge wants. I mean, I know Trump's greedy. Will he ask for another paper? Probably. Will the judge give it to him? Maybe 4 or 5 pages more. But that's it. Then this judge is going to decide what to do right now, before the inauguration, after the inauguration, with the conviction and the sentencing. So I turn it over to you.
Yeah, so this is a dismissal in the interest of justice motion, which is kind of unusual here. It's called a Clayton motion, named after a case. And a dismissal in the interest of justice, those are for things like, my client is elderly and infirm and being prosecuted or going to jail, or he's very sick, he's about to die, please dismiss this case and let him be with his family. I mean, these are very unusual motions to make a dismissal in the interest of justice. And so that it's a case, and the case lays out a certain number of factors, like 12 different factors that you're supposed to consider in whether or not you're going to do a dismissal in the interest of justice. And the Manhattan DA's office did a great job, I thought, here, basically saying they don't meet any of these criteria for dismissal, because don't forget, this is not about presidential immunity. That's being litigated separately in their post-verdict motion, which is called a CPL section 330.30 motion. That's on hold right now. There's several motions, as you said, that are on hold, or that they're trying to get to be on hold, that are still pending, that haven't been ruled on. But this is a separate motion that they're trying to say, wait a minute, those other motions, don't decide them, dismiss the case. This jury verdict that came down, that shouldn't exist. We want the jury verdict to be thrown out, and I want you to dismiss the case. Don't rule on presidential immunity. Don't sentence him. Don't pass go. This should be a get out of jail free card. And so they had to find a way to bring this "we want the case dismissed" motion, and they had to find a place to kind of fit it in. And where would you do it? And they came up with this procedure, do it in the interest of justice, which I thought was kind of a huge stretch. And the Manhattan DA's office did a great job at shutting that down. And, they start with the fact that, look, presidential immunity, first of all, this whole thing about presidential immunity and why one of the reasons it should be dismissed, that doesn't attach until he becomes president January 20th, which is soon. But that's not right now, and we can decide those other motions, right? You still have time to do that because that's not until January. And there's no need for this extreme remedy of dismissal. What's the point of it, right? Let's just press pause on this case, and you can deal with it later when you're no longer president. This is in a very different procedural posture than the Jack Smith cases, right? Those cases were just getting started, just pending. There's lots of motion practice to happen. Trial dates hadn't even been set yet. And in fact, with the Mar-a-Lago case, that case was dismissed by Judge Cannon and is on appeal. So those cases are in totally different procedural postures. This case, there's already a conviction. And they say that there's already a conviction here because there is. And so this is just a matter of sentencing and some motion practice that's been fully briefed, right? All that other motion practice on presidential immunity and whether it applies here, all of that's been fully briefed. Just a matter of ruling on that and appealing it, obviously, and sentence. No, we can wait until after he's president to address those things. Why would you disrupt the jury verdict that happened here in order to do this very extreme remedy of dismissal? And they said, look, the Clayton or interest of justice motion, it has to be a compelling factor for dismissal. And they list all of the various things that you're supposed to consider. How serious is the crime? How much harm was caused by the crime? How strong is the evidence of guilt? The history, character, and nature of the defendant. That's my favorite section of this motion. We'll talk about in a minute. And what's the purpose of imposing a sentence on the defendant? What would the impact of the dismissal be? And how does the complainant feel about it? And any other relevant factors. It's sort of this general catch-all interest of justice motion. Like I said, I've responded to many of them, and none fit into this category. And so they basically, they really kind of hit every factor and talk about, this is a very serious case. And this is something that matters a lot. And, for Trump to say something like, oh, this is my first time I've ever been convicted of a crime. I have no criminal history. And also I've done so much great public service. Well, guess what? That applies to every political figure, like Mayor Adams of New York City, for example, who's being accused of a crime. Every public corruption case is usually first, no criminal record and history of public service, right? That doesn't matter. Obviously, it's a factor, but that's no reason to dismiss a case. And also, this was for unofficial conduct, right? So should be temporary immunity. This is not permanent immunity for official conduct, the way presidential immunity applies in some of the Jack Smith case that they already dismissed. So they also said, look, pressing pause and waiting till after he's president is not going to interfere with the office, so that's not a problem. And look, being president doesn't require pausing everything, as we know from other cases, right? There's the Nixon case, the Fitzgerald case, the Clinton case, right? Clinton and Paula Jones, in that matter, yes, it was civil, but he had to sit for depositions because that was entirely personal. So they're saying, look, nothing here, because we're willing to press pause, would interfere with his presidency. And so this extraordinary relief that he's seeking, this dismissal, doesn't apply. But, like I said, they go through all the factors. They talk about why this case is serious, why it matters. And there's two things I just want to hit upon. One is what you touched on, Popok, which is they're saying, Instead, you should analogize to this concept of abatement by death, right? I just thought that was an interesting analogy. So in New York, when somebody dies and their case is on appeal, the case is actually dismissed. It's abated by death. But in the majority of the country, in New York's, the Manhattan DA's office in many cases, and in the majority of the country, they're trying to say that should change. And instead, you should adopt something called the Alabama rule, which basically says if a defendant dies after guilt, but before the appellate process, rather than dismissing the case outright, instead you put a notation on it that basically says this is neither affirmed nor reversed, but it's but the defendant died. And also, by the way, the presumption of innocence no longer applies. Here, it's a very similar situation. So they're saying apply that standard here, because this is obviously unique, right? This presidential immunity is something that didn't exist before. And so there are no cases that support it. So they're trying to draw analogies to how other jurisdictions handle other cases that they're trying to fit in this sui generis, or this very unique situation. But like I said, my favorite part of this whole thing is when they talk about the history, character, and condition of the defendant, right? And they basically list all the things. Yeah, you say the defendant was a public servant when he was president. Yeah, you say he wasn't arrested before. But in this case, during the pendency of this case, the defendant attacks the criminal proceedings and repeatedly violated court orders, right? There's extensive evidence of the defendant threatening the prosecutors, the judge, the grand jurors, the witnesses, right? He used inflammatory language. He denigrated people. He used public attacks on local and federal officials, right? On court staff, personnel, family members, you name it. And this pattern, and he talked about Judge Engoron and attacking Judge Engoron and his family members. He talked about Letitia James. They even talked about E. Jean Carroll and what he did there. They talked about the death and destruction comment that he made, calling for the whole death and destruction, and then the baseball bat to Alvin Bragg's case, calling the grand jury human scum, just all the things that they did over and over again. And they really outlined it, I thought, and reminded people of how the defendant comported himself and actually how atrocious and outrageous it was, and how the judge here had to hold him in contempt 10 times, how they threatened Jack Smith, his wife, his sister-in-law. I mean, when you think about it, I always say this, any other defendant in any other situation would have been incarcerated immediately and not allowed to continue on this campaign of just lawless behavior. So there's nothing about his behavior or the nature of who he is that requires dismissal. In fact, it's the opposite. So I thought they did a really great job doing all of that and really shutting down these arguments.
Yeah, I don't think the judge is going to buy any of this. I think the judge has about 3 different decisions that he has to make, Judge Merchan. I think the first one is, when is he going to sentence, not if he's going to sentence. I think he'll quickly conclude that he's not going to vacate or throw out a conviction by 12 jurors who worked, tirelessly through a lot of headwinds and turbulence created by Donald Trump himself around the trial, where they were getting attacked, the process was getting attacked, the judge was getting attacked, and everybody was getting attacked. But yet they came up with a way. We sometimes shorthand it by saying he was convicted of 34 felony counts. He has 34 convictions, one each, for business record fraud and in furtherance of a second crime. And it is unprecedented. And they like to say, oh, we've never had a incoming president-elect and then president. Yeah, we never had a criminal president or criminal candidate be elected again to the presidency. But you have to carefully go through the immunity decisions. I think they did a good job at picking that out. They said there is no president-elect immunity, so let's forget that. But we're going to be, so judge either sentence before Jan 20, which you could do, but we understand that the actual start of the sentence, whatever you impose of its jail time, would start after the 4 years. Time heals all wounds. Time resolves temporary immunity. Just wait 4 years. They also said in their paper that, and they're right about this, there's a speedy trial, Sixth Amendment concern, that yes, the defendant can waive it, but public justice demands that there be the imposition of a trial, a sentence at the end of a trial. The people don't think, oh, that was it. There was a trial. There's no sentence. I mean, for both sides of the equation, you're supposed to want to have a sentence. So impose it, but delay it, abate it. That's one thing you could do. Or they said, make a note. You could terminate the proceedings, but which is back to your Alabama rule or your abatement by death, and make a note that says the verdict stands, and the sentencing will be postponed until a later time. Pick up with it 4 years from now. That seems like in a time we can't wait for it to be over. It hasn't even started yet. His next presidency, but it will be over. I've been involved with cases that have gone on almost 9 years. It's just in the civil matters. So what I think the judge is going to do is, I think Trump's going to ask for another piece of paper because he's greedy. I think the judge, just to have a clear record, will probably go, all right, 5 more pages. Then he's going to rule on the immunity. No, there's no immunity here for you. He's not going to find intra-agency supremacy immunity. He's not going to find any of these things justify taking a jury verdict and ripping it in half and throwing it away just because you happen to win the presidency. There's nothing in there that says that. And the only issue is that everybody seems to agree that he's not going to go to jail during the presidency. And so the sentencing can be after the presidency. And to the argument that Donald Trump invariably has made, which is, I can't have the shadow, the public condemnation of serving time hanging over my administration for 4 years. There's also nothing in the books that says you use a magic eraser or a time machine to resolve the issue as he's going into the presidency that already happened. He's already been subject to scorn and public ridicule because he got convicted 34 times. There's no etch-a-sketch that solves this problem just because he became the president. And so I think that gets quickly dispatched. I mean, this brief, even though it was a little bit longer than I thought it would be, there are, like, as you said, like 8 or 9 factors that have to be analyzed. And by the time they were done analyzing it, including the one where they've outlined all the ways, as you said, he violated the rules of the court, public justice, attacked everybody, which we knew would show up. And then they had a nice section where they outlined all the evidence against Donald Trump, all the Michael Cohen testimony corroborated by other people, all the documents, all the witnesses, because it just shows you the strength of the conviction. Because again, this is a unique motion brought under in the interest of justice, and which has that factor analysis. He's going to deny this. He's going to deny the immunity. It's going to go up on appeal to the 2 levels of appeal. And sometime in 2025, there's going to be a decision about when the sentencing happens and how it gets handled. But he doesn't get a magic eraser board of, because I've won the presidency, all my bad acts get absolved, right? This is not a confession in Catholic Church.
I agree. The sentencing is not going to happen, but obviously, it's not going to happen until 4 years from now. It's just not. And whether there's any proceedings about when the sentencing happens, or any appeals or presidential immunity, I think that's TBD during all of this. I think the big question is, Judge Merchan has to deny this. Will they appeal it? Hopefully, the status quo will occur and everything will just be on pause. I mean, look, they might want to keep litigating this, but on the one hand, you can't argue on the one hand, we're too busy, we can't litigate this because we can't be distracted from being president, and then litigate this issue constantly. Presidential immunity, dismissal. They're sort of arguing against themselves, right? Either they're too busy and it's too distracting to litigate these things, or it's not. But let's see what they do and how they keep going. It'll be interesting to see.
And we'll continue to follow it on the MeidasTouch Network and on Legal AF Midweek. Karen's back tomorrow for the midweek edition with me of Legal AF here on the MeidasTouch Network. We got a Saturday edition, of course, with Ben Meiselas and me. Got hot takes all along the way. Got the new channel, Legal AF, the YouTube channel. And Karen, of course, is on Mistrial, which I think is on Thursdays here on the MeidasTouch Network. And that's where you can go for the update at the intersection of law and politics. So until our next All Things Legal AF and updates related, Karen Friedman Agnifilo recovering. You would never know it, Karen, that you got a leg up literally on this podcast. And we'll see you tomorrow along with our audience. And Michael Popok, Karen Friedman Agnifilo signing off. In collaboration with the MeidasTouch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.